On 17th August 2023, Buganda Road Court Chief Magistrate Muhoozi Kainerugaba allowed prosecution to take the file for review in High Court in the case filed by lawyer Hassan Male Mabirizi against General Muhoozi Kainerugaba and 7 others. Among the issues to be determined by High Court was whether the complainant Hassan Male Mabirizi had locus to amend the charge sheet by adding more suspects, and whether the matter was amendable for review, and whether the laws were followed in transferring and taking the file from City Hall Court by the Director of Public Prosecutions. Although this case was not right for review, Judge Micheal Eluburu determined the other grounds. Basing his ruling under Article 120 of the Constitution, the Director of Public Prosecutions Office has a right to take over any case and at any time.
His complaint that his right to be heard was flouted is therefore unfounded. This file is now before this court, and no court can sanction any illegality that comes to its notice.
Judge Micheal Eluburu said under Provision 171 and 221 of the Chief Magistrates Act, the Trial Magistrate Muhoozi Kainerugaba acted lawfully to take over the file from the City Hall Court.
Magistrate cannot be faulted in any way for legitimately exercising a statutory prerogative to call for, transfer, and take over the hearing of the file. In the result, it is directed that the amended charge sheet filed on the 13th July 2023 was received in error and is accordingly struck out.
However, court nullified the amendments made in the charge sheet by the complainant Hassan Male Mabirizi by adding more suspects.
It was argued for the Mabirizi that he had just filed the case and summons had not been issued. It was certainly not a bar as shown above. After the takeover, the DPP became the only proper party in the matter and assumed prosecution control.
Court kicked out Hassan Male Mabirizi in this matter, allowing DPP's office to take over the file. The complainant Hassan Male Mabirizi vowed to appeal the ruling.
Because Judge Eluburu is contradicting himself. You cannot say in one issue that the matter is not amenable to revision. Then after that, you go ahead and revise the record that the parties were illegally added, that I had no locus. They are serious matters. For example, what about fair hearing? If I file my case and I'm in prison, you claim to take over and you don't serve me. Yet the court order was the record was so clear that you serve the respondent. You serve the private prosecutor.
He also highlights the reasons why on several occasions he objects to taking over his case by the DPP's office.
So far I have more than 3 cases where our board has taken over and this continued under her hand. The fresh one is Chagulanyi's case at LDC court. Everything was clear. They took over, they never came back to court. The time they came back to court, it was a withdrawal. So the DPP's office has been used to abuse the process, contrary to the Constitution. So if we cannot allow them to keep taking over our cases, and this is a matter which the Constitutional Court noted in Kainerugab's case, that the Constitution tells you to take over and continue.
Prosecution in this matter was represented by Ivan Chaze, Deborah Namamonde, UBC News.